Good afternoon. Welcome to the 10th, what is now the 10th in a series of annual lectures to honor Judge Thomas Fairchild, who we again have the joy of having with us here for the event. This event, as those of you who have attended in the past know, was organized by a committee of the judge's law clerks to honor him. And as I think about today's topic and today's lecture, I can't help but be quite impressed by the how exquisite the timing of the committee was, both in terms of history and in terms of the contemporary. As to history, maybe some of you have overlooked the fact that this week marks the 25th anniversary of the Saturday Night Massacre, something that the judge will be addressing as part of his remarks. And certainly, obviously, in terms of the contemporary, the events that we read about in our daily newspapers and see reported in television journalism, I think, have brought home to even the most casual observer that the topic of the role and the power of special prosecutors is one of the most dramatic and controversial issues facing us today. Today's speaker is eminently qualified to bring his thoughts to bear on those issues. Certainly when we think about Judge Lawrence E. Walsh, we of course think about his service as independent counsel during the Iran-Contra investigations from 1986 to 1993. And given the significance of that service, I think it's sort of tempting to somehow forget the fact that all of that activity actually followed his retirement from a legal career that is distinguished by any measure whatsoever, and certainly something that I know when I was a young lawyer, I thought identified him as one of my heroes. He began as a young prosecutor in the office of Thomas Dewey during Dewey's racket-busting days as the New York District Attorney, and he later on then followed then Governor Dewey to the State House in Albany. Soon thereafter, Judge Walsh was to begin a long career of federal service. He was appointed by President Eisenhower to be a district court judge in the Southern District of New York, and then resigned that post to be President Eisenhower's Deputy Attorney General. In that post, he was responsible for overseeing the continued desegregation of public schools after the military forces had been withdrawn from Little Rock, and he was the principal drafter of the Civil Rights Act of 1960. Following his government service, Judge Walsh was a partner and a litigator at the New York firm of Davis, Polk, and Wardwell for 20 years, but that hardly meant an end to his distinguished career. Excuse me, I'm not good at juggling both script and microphone at once here. His distinguished career of public service. In 1969, he was President Nixon's personal representative and deputy head of the U.S. delegation to the Paris meetings on Vietnam in the preliminary efforts to find a basis for ending the conflict. And he thereafter served in a wide variety of posts, including as president of the American Bar Association in 1975 to 76. His lecture today is entitled "The Future of the Independent Counsel Law," so please join me in welcoming Judge Lawrence E. Walsh. Now let's get this right and I'll get out of your way. If you want to,
how did I do this?
fix that to your time. All right. How's that? And then you can put that where you want.
Well, for somebody who couldn't get the door unlocked last night, I hope I work out, do a better job on this. And if anybody in this room or any other room that's trying to listen can't hear me, just let me know. I just deeply grateful to be here. I say nothing about the weather, but just the occasion of being here and to be with Dean Davis and to honor Judge Fairchild is something that I think most lawyers in the country would would envy and would like to do. I had the pleasure of knowing Judge Fairchild for many years. When I became emeritus member of the ALI Council, I made room for the next senior member, which is the judge. And just to know someone who has accomplished so much, who's been both in politics in his early life, developing a party where almost none existed, who then became a prosecutor, and then a distinguished and admired judge, and to do it with such modesty and with such almost casualness is, I think, a model for all of us who want to practice law. The ability to accomplish so much, to be so outstanding, and to be so modest and quiet about it. So it so contrasts with the flamboyance that you see in other areas that I can't think of a better role model for this school or for any other school who's interested in this profession. I was invited here to talk about the renewal of the independent counsel law. Congress very wisely and distrustingly provided when it was first enacted that it would have to be renewed every 5 years. 1 year it didn't make it. That was the year I was working. And only after I left did Congress renew the act. But this is coming up again now in 1999, and I think it's going to have some troubles. I think they've forgotten what I did, but Judge Starr has managed to get his name in the paper quite regularly, and I think this will produce an interesting subject in the spring when the committee hearings start. I see a number of students here, and I take a moment to try to get a broader look at this funny specimen, the independent counsel. The rule of law is something that we all are very proud of. Lawyers conceived the idea that the law was the supreme force and that everybody, even the king, was subordinate to it. Bracton in the 13th century said, the king is beneath no man, but beneath God and the law, for the law maketh the king. And then you've all probably seen engravings of Judge Coke confronting James I and saying to him that he was beneath the law, and James I saying Coke was guilty of treason for asserting it. So lawyers have had their ups and downs even before there were independent counsel. But the truth of the matter is that although the lawyers conceived of this philosophical view that the law was the supreme force, it was the politicians in one form or another, either armed barons or other political forces who forced the acceptance of this thesis by the ruling forces. And the Magna Carta, the Parliament, were all results of forceful political figures in making the king do something he didn't really want to do. And then, of course, the American Revolution, when we broke with the mother country because the colonists were denied the right of English law by autocratic governors, led to the embodiment, embedding of this thesis here, which is epitomized by John Adams' wonderful line at the end of the Massachusetts Constitution that we may be a government of laws and not of men. Well, then you come to sort of a steep drop in the progression of these high thoughts when you look at who was given the job of enforcing this great principle as to the president and as to the highest officers in our country. And it's not somebody appointed by a president or even confirmed by the Senate. It's just a lawyer drawn out of private practice appointed by 3 appellate judges. And there's somehow there aren't the right number of trappings or to go with the high-sounding objective of the job. But Be that as is, we've done the best we can with what we had. As the dean said, we marked the anniversary of Watergate, of the Watergate Saturday Night Massacre, which led to this law. The morning after that Saturday night, when Archie Cox was fired as independent prosecutor, the Attorney General resigned, the Deputy Attorney General resigned, and they had to go down to the number 3 man in the department to carry out the president's order to fire Cox. The president of the American Bar Association had called me. I was then on the board, and we decided that this was a time to speak out, and he did. And he, I think, led the public outrage at what had happened. And he created a special committee of the ABA to develop legislation so this would not happen again. And that report of that committee was drawn into the other work of the congressional committees and resulted in the present law. The law is relatively simple. The most important provision, perhaps, is that the independent counsel cannot be fired arbitrarily. He can be removed by the Attorney General, but only for cause and after a hearing before the District Court of the District of Columbia. The law then went further, however, and deprived the Attorney General of the power of appointing her successor where she had a conflict of interest, and assigned this responsibility to 3 Court of Appeals judges, 1 from the District of Columbia and 2 from other circuits, who were given the power of selecting the independent counsel. It also no longer left to the Attorney General the decision of whether or not she had a conflict of interest. It mandated the use of an independent counsel wherever there was credible and specific evidence of a violation of the criminal law other than a petty offense by the president and about 75 or 100 other senior officers in the government, or the cabinet officers, high officials in the CIA and other agencies, and also high officers in political organizations who might have had dealings in connection with the campaigns that elected the president. So this really went beyond the immediate needs of the Saturday night massacre. It went beyond protecting an independent counsel. It took over the machinery for his appointment, and as we said, have assigned it to the court. Now, there have been about 20 independent counsel have served in the time since then, and most of them got along very well. The great value, it turned out, of this kind of an independent counsel was that he could credibly decide not to prosecute. The value that better than the Attorney General, who might have a friendship or a relationship with somebody in the administration. An independent counsel coming to the conclusion that there were no grounds for prosecution was better accepted, and it was usually carried out. His decision would usually be in a lengthy report giving his reasons and laying to rest the supposed violation of the law and restoring, in a sense, the person who'd been under investigation. But there were 3 where there were indictments and convictions. Mike Seymour just before me, and my own, and now Judge Arlen Adams, who investigated the Housing and Urban Affairs Agency, and is just finished. There are 5 ongoing independent counsel, of whom 3 have returned have had indictments returned, and 1 star has had trials and convictions. I thought, just trying to think how to focus best on the need for something like this, and then come to the criticisms of it. And I think if I describe, there were only two of these independent counsel who dealt with the president. The others were dealing with subordinate officers. But I dealt with President Reagan's problems in Iran-Contra, and of course Kenneth Starr is dealing with problems with President Clinton now. And as you might expect, these are the agencies that have received the most criticism. I mean, these are the independent counsel who have received the most criticism. They've been the most exposed, and they, I think, point out both the strengths and weaknesses of the office. In Iran-Contra, there were 3 interlocked conspiracies in the 1980s. President Reagan supported the Contras, a counter-revolutionary group that was opposing a communist-dominated government in Nicaragua. And when the Sandinistas, the communist group, came in, they began to permit the flow of weapons from Russia to Cuba and then into Nicaragua, and from Nicaragua out into Central America, where they were being a danger to to destabilize Central America and on our southern border. And President Reagan was convinced that this had to be blocked, and the most effective way to do it was to support the Contras, which Congress went along with until the CIA, who was the liaison with the Contras, became over-exuberant and mined the harbors of Nicaragua, damaged neutral shipping, got us drawn into a world court case, and we had to deny jurisdiction to the world court. And the Congress then said, enough, we'll cut this off. You're not blocking the flow of arms. You may even be trying to overthrow the government of Nicaragua. And Congress put a provision into the Budget Act that prohibited the use of intelligence agencies or any intelligence entity or their funds to support the Contras. And this was a terrible setback for President Reagan, and he considered going to this was 1984, it was an election year. He considered making this an issue. But his advisors told him that it may go well in parts of the West and parts of the South, but it won't go well in the East, where everyone is still thinking of Vietnam, and we don't want another Vietnam in Nicaragua. So they persuaded him not to make an open attack on it. But so he then decided, well, I'll do it by deception and by trickery, which was probably a mistaken decision, but I don't know. But anyhow, we'll just tell you what he did, and you can decide. He needed money, so he sent the national security advisor to the Saudi ambassador, and he explained to the Saudi ambassador it was very embarrassing to the president to have to leave these Contras out in the field after they left their home. We have a lot in common. We're supporting you in the Middle East, and we could use some support now. And the Saudis came up with $1 million a month for the Contras. So that what you have is a president who is blocked by Congress from using American funds, who then pursues the policy that Congress tried to block by using Saudi funds. Because the CIA had been specifically told to stay out of this, he had to find someone else to be a liaison with the Contras, and his national security advisor picked Colonel North, who was a very dedicated Marine officer, done well in Vietnam, been decorated, and was ready to try almost anything that would move along these lines, attract the president's attention, and at the same time fight communism. So he replaced the CIA as our liaison and developed a supply system for the Contras. It was so effective that the Contras began to grow instead of decrease, and was doing very well, except that in Washington nobody can keep a secret. And as North succeeded, his very success exposed him to questions by Congress. And this shows what happens when the president takes the bit in his teeth. They don't question the president. They start to question his subordinates. and here's poor North caught in the middle. They try lying by letter, and then the Congress presses harder the second year and calls North before the Intelligence Committee, and he has to lie up and down, deny all the things he's doing. I'll drop the story there for a minute as to North. They go to the second part of the interlocking conspiracies, which was getting the hostages free from Iran. There was a militant, I'm afraid I get off into the anecdotes and get away from my legal discussion, but I'll come back to it. There was a militant Islamic group in Lebanon who kidnapped 8 Americans. And one of them was the chief of station of the CIA. He was the person who was privy to all of our clandestine activities in the Middle East. And they were torturing him. It was a miserable situation. And the president had a natural sympathy for these hostages, and the head of the CIA, Bill Casey, one thing he wanted was to get that man out. But we had a strong policy against dealing with hostages, because if you make it profitable to take hostages, the hostage takers will simply take more. They may release a few, but they'll take twice as many. And we'd gotten our allies to agree to this policy. And I heard the president talking to the ABA saying that he would never deal with hostages. But the Israelis persuaded him that he could sell arms to Iran during the Iran-Iraq war, when we were supposed to be neutral. Sell it through the Israelis, and the Iranian government would persuade the militant Islamic group who were sympathetic with the Iranians to release the hostages. Well, they started that. One hostage got out, but then the Israelis got into a problem with the second shipment, sending lower grade material than they'd promised, and they couldn't deliver it, and they had to get the CIA in to carry out the delivery through a proprietary. And it was a violation of the Arms Export Control Law to sell the arms, even through Israel. And it was a violation of the National Security Act to deliver it through the CIA. So they finally got the Israelis out of the picture, and we started direct sales. And this came at a fortuitous time that links the first two conspiracies, because the Saudi money ran out. North needed money for the Contras, and North was given the job of carrying on the sale of arms to Iran, and all he did was inflate the charge by 300%, skim the extra 200% off for the Contras without even bother to go through the Treasury or the Congress or the appropriations. So those are the first two conspiracies. They both are exposed within 3 weeks of each other. One of North's aircraft was shot down. The surviving crew member says he works for the CIA. Then, in addition to questioning North, they questioned the top officials of the CIA, the top officials of the State Department, and like North, they all have to lie to protect the president, which again comes back to what happens when you have a well-intended, patriotic president, but a willful one. So the next 3 weeks later, the story of the arms sales come out, and the Congress then is trebly infuriated and starts hearings. This is just a long way of getting around to the Attorney General and why he had to disqualify himself, because as these exposures come out, the State Department begins to contradict the CIA. The State Department wants to tell the truth. We did authorize this. The CIA wants to say nobody in the government even knew about it. The Attorney General, Meese, who was really a very close advisor of President Reagan, is called in to develop a, quote, coherent administration position, which he does by getting all of the top foreign policy advisors in a room with the President, the Vice President, Secretary of State Casey, and the National Security Advisor, and telling them, the Chief of Staff of the President then throws up a question: did the President know about this? And Mies says, no, he did not. And if he did, he'd be breaking the law. Now, fortunately, there are a lot of people who are going to write books, and so they're making notes as all of this goes on. But they're hiding them. They're lying about it. They don't produce it. But anyhow, ultimately, we find the story. And then Mies's assistants find a memorandum in North's file which exposes the whole thing, how he was going to raise $12 million for the Contras in this fashion. And that had gone to Poindexter, the National Security Advisor, and perhaps to the President. Everyone has always denied it. But when they found that, then Donald Regan starts to make notes for his book. He was the Chief of Staff. And he says, tough as it seems, we're going to have to claim a runaway conspiracy and blame it on the National Security Council staff, which they then do. Poindexter resigns, North gets fired, and then the Attorney General asks for an independent counsel, because obviously he is in the middle of this and can't. So that's one way you get into this problem. If I had more time, I would tell you about the interesting conflicts between an independent counsel trying to prosecute crime and Congress trying to expose activities through using their powers of government oversight. You really have a double check on the presidency, the political check of government oversight through Congress and the prosecutorial check through the courts and with an independent counsel following the criminal side of it. Congress wants to move quickly. They promise a report in 6 months. Impossible to get through all this tangle in 6 months. They then begin to nag at me for not moving faster, prosecute North for destroying his records, and go home, which would carry out the effort to throw the blame away from the president. Instead of that, they give immunity to North. They're unable to control him on examination. He runs away with the show. Congress ends up with a report saying that it was North and Poindexter, that the cabinet reaches weren't, they didn't even call some of the cabinet members. And so that's the way that one ends. Now you come back to Starr, by contrast, and I'd hoped to be almost through here by now, but it's going to take a little longer. I hope you bear with me. Starr, by contrast, is given a job. It's a tough job. In 1994, when the act was not renewed, question was raised about President Clinton's activities in Whitewater and a real estate deal before he was elected. And the Attorney General concludes that obviously she's disqualified and needs an independent counsel. And she appoints a very respected one, a former United States attorney from New York, Robert Fisk. And he moves right in, and he quickly phases up one phase, the Vincent Foster death, and he's moving along, but then Congress reenacts the independent counsel law. And the Attorney General asks the new committee to reappoint Fisk under the law. And they say, no, we can't do that. We have to be independent of the Attorney General. We can't appoint somebody, no matter how good, if she's already appointed him. So then they turn to Kenneth Starr, who is a former Court of Appeals judge, a former colleague of Judge Santel, who was then the head of the appointive division, former Solicitor General, but he's never tried a case, he never investigated anything, and he's never prosecuted anybody. So you have a person of distinction, but without the qualifications for the job, getting it. And he turns to with a tough staff and begins the investigation of this Whitewater, this matter that happened many years before, a difficult job. I really sympathize with him, and I would never criticize him during that period. But it was an assignment that drew off millions of dollars into trying to find out something that happened before the president took office. There were other additions to his job dealing with, it came up during the president's term, like use of FBI files, which apparently the president wasn't part of, and the firing of the travel agency for whatever that may amount to. But 4 years after he starts, he then finds out about the president's relationship with Monica Lewinsky. And this comes to him through a friend of Miss Lewinsky's, as we all know, who had drawn her into conversations about the relationship. But the sexual relationship, whether you like it or whether you don't like it, whatever you want to say about it, isn't criminal. So that it's not an avenue for investigation in itself. He looks to see whether there is an obstruction of justice that he can put his finger on. He had, and what he finds is that the president and Ms. Lewinsky had agreed that they would keep secret their relationship, and that the relationship had come to an end long before there was any question of obstructing justice, and that even that the president's friends had tried to get her a job in New York, to get her out of Washington, before she'd been named as a witness in the case. All of these things are non-criminal. Then she's named as a witness in the Paula Jones case. And the question is whether there was an acceleration of this job hunting activity after that in an effort to get her to change her, to deny the relationship. And she has given immunity. She testifies that she was not asked to give false testimony. The president denies it. The president's friends, Vernon Jordan, deny it. But this was the hold that Mr. Starr saw to the rationalization for a criminal investigation of the otherwise non-criminal, however revolting, sexual activity. After he starts on that, the president is called for a deposition in the Jones case. And as we all know, gave hair-splitting answers at best, and maybe one or two that were false. But those of you who've tried cases know that in civil cases, the deposition exchange is rarely a perfect vehicle for the truth. What you have is as private litigants start off with the extreme views of each other, they get closer and closer together, and in the depositions, they haven't quite reached it yet. You have people who are withholding information. The lawyers are saying, don't volunteer anything. You're not trying to convince the lawyer who's questioning you. The lawyer who's questioning them is always trying to decide, should I cross-examine more precisely now in order to develop the facts of this deposition, or should I let the lie stand and then expose it more dramatically at trial when I'll be able to do it very effectively? So the Paula Jones lawyers decide they're going to let these answers stand without very much cross-examination. But Starr decides that he's going to move right in, and he's going to develop the truth or falsity of the president's statements in the deposition by conducting a multi-month investigation of these sexual activities. Now, this is I think, unprecedented. I don't know of any case. There are cases of perjury in civil cases being prosecuted, but not of a U.S. attorney jumping in before the case even gets to trial and prosecuting for a pretrial activity in that case. Ordinarily, if something is done wrong in a civil case before trial, these all work up to trial, and in the end, it all comes out before the judge and the jury. And the judge either punishes somebody if that's necessary, or the jury makes a decision that somebody is lying, if that's necessary, and they get to a verdict and the case is ended. Rarely does a U.S. attorney come in at all, but I've never heard of him coming in before the case and even asking the judge in the civil case to postpone the development of the civil case so that the independent counsel can investigate the truth or falsity of this deposition. The judge refuses to postpone and says it's of so little relevance that we'll just throw that out of the case. And then later she dismissed the case for other reasons. But it's on such a thin reed that this investigation goes forward for many months that then ends up in an exposure of this lurid story, which then is reported to Congress as a possible basis for investigation. I've taken a lot too much time on the facts. I'll come quickly to the criticisms of the Act. The first criticism, when the Act's constitutionality was in question, Morrison against Olson, by 8-1, the court upheld its constitutionality. I think 7-1. Justice Scalia dissented with a very perceptive observation, and he quoted former Justice Jackson to the effect that if you permit that it has this single-mindedness, you have a prosecutor with a predetermined target, rather than a prosecutor who's simply looking around at crimes in the community and looking into this crime or that crime to see who did it. Here you have him looking at a particular person to see whether he committed a crime. And the famous quote of Jackson was that, with so many laws and regulations, it's a pretty poor prosecutor who can't find at least one that he was broken and that therefore he would have a basis for prosecution. But the Supreme Court didn't agree with Justice Scalia, and there's a fallacy in his point as an argument against the Independent Counsel Act, because the same criticism could be made whether the independent counsel was appointed by the Attorney General or appointed by the court under the Act. It's not really an argument against the Act. It's against ever having an independent counsel, even with a conflict of interest by the Attorney General. But it points out an evil to be watched and for. I don't think it's a persuasive condemnation of the Act. Professor Gerard Lynch at Columbia, who worked briefly with me and was head of the criminal division in the U.S. Attorney's Office in New York and teaches criminal law at Columbia now, that also joined in an article condemning the Independent Counsel Act, pointing out the difference between an ordinary prosecutor who has hundreds of cases, and when he makes a decision to prosecute, which is really a terrible decision as far as the poor guy getting prosecuted is concerned, he's doing it against a background of scores of cases. He knows what he did in this case, he knows what he didn't do in that case, and in a sense of fairness, not just what the letter of the law provides, but a sense of what is consistent with what has been done in other cases. He makes a more subtle judgment as to whether a case should be prosecuted or not. Whereas an independent counsel is really deprived of that kind of testing. He may not pick out the target himself, the court picks out the target, but he's given the job of going ahead after this one target and no others, or there may be some related targets. But it's all one narrow proceeding. And there's a great temptation to become over-intensive in such a thing. I'm not criticizing Starr, I'm criticizing myself. We both received the same kind of criticism. And what you do as you become intensive and you're trying to get people to assist you and tell you the truth when they don't want to, there's a great temptation to start prosecuting those people for something they've done wrong. Tax problems or making a false statement. In my case, everybody made a false statement to Congress at one time or another. So it was just a matter of picking out which one. It's an unpleasant thing because these are people at the top of government. They're people who've been courageous. They risked their lives for the CIA. And you're going to destroy them, make them go broke trying to defend themselves with a high expense of defense these days, because you're prosecuting them, because they've done the bad thing. They've told a lie to Congress and tried to conceal an activity that Congress had forbidden, which is bad enough. But query whether you would be doing it if you weren't looking for their testimony too. And Starr has had a similar experience in Arkansas. He's been charged. People are complaining he's being very tough, ruthless down there, trying to get people to do it. But this happens also in a regular prosecutor's office too. I mean, some perhaps more than others, but even though a prosecutor may be dealing with hundreds or thousands of cases, there's always one or two that are getting special attention. When I was in the district attorney's office long ago, there would be the racket cases. I mean, Lepke and Garra were killing people, killing witnesses. Believe me, they got a lot more attention than the run-of-the-mill case coming in. And there was a group of people that did nothing but trying to figure out how to get them, and they finally got them. And Lepke was ultimately executed. But it's a difference of degree, really. Not exactly a kind, and it's a problem that's there, but it's going to be there no matter how an independent counsel is selected. And I don't think we can get along always without independent counsel, because there are some cases where the Attorney General is just obviously disqualified, and you're going to have to get somebody. But the second area of criticism is that the scope of the act is too broad, that it embraces too many people as to whom the Attorney General really doesn't have a conflict of interest. The development of the government has been so immense that there isn't that degree of intimacy between justice and housing and justice and commerce that there may have been 50 years ago. And so that I think many of us who've worked in this area and who are concerned about the complaints about expense and the number of independent counsel being appointed have suggested that the mandatory feature be limited to the President, Vice President, and the Attorney General, and that the rest of it be left to the Attorney General's judgment as to whether she has a conflict of interest or not. Now that comes to the next point. How should the appointment be made? Should we keep the judicial unit as the appointing group? Or should go back to the old rule that we had for 100 years, where if the Attorney General decided to disqualify herself, she would pick the independent counsel? And I think the Starr appointment is going to pose a problem in this regard. I'm not here to criticize it, but as I said earlier, you had a good prosecutor in there, unfortunately a contrast with Starr, a man who is a seasoned prosecutor and an all-time trial lawyer and litigator. And you replace him with Starr, who is an obviously active Republican, a party opposite to President Clinton, and he was himself put out of office when Clinton defeated Bush in 1992. And so it's a sort of an awkward relationship to come back and then start investigating the president who just defeated your boss. But that's what the committee did. And I don't know the explanation of it, and my guess is that this is going to be a subject of investigation by the committee, by a congressional committee, when this act comes up for renewal, as it must next spring. And that they're not just going to be looking at whether Starr was guilty of excesses, but also as to whether he, getting all the facts about all the rumors about his appointment in the first place. I'd like to point out in fairness that this committee, which is going to perhaps have to withstand this scrutiny, has appointed 5 other independent counsel, as to whom there's been no significant criticism and no quarrel. They've all gone ahead and they seem to be doing their work very effectively. So it may just be an aberration, but it's an aberration that certainly focused a lot of attention. It's going on. I come now to what I think is the most important change that should be made in the Act, and that is that the crimes subject to this kind of intensive investigation should be limited to crimes related to the discharge of the duties of office. They should not be crimes that something that happened before a person was elected. As to that, let the statute of limitations be suspended and let him stand trial after he gets out of office. Not in the interest of the individual, but in the interest of the United States, who wants a full-time president. We all know that if a case is delayed, it doesn't do it any good. It probably hurts it. Witnesses begin to, their memory falters and things like that. But that's a price we should be willing to pay to avoid this awful intrusion of an excessively intensive independent counsel's investigation when a man is trying to bring Israel and Palestine together or do whatever, the Palestinians together. It's always one thing after another. There is no free time down there. And to distract him with threats of impeachment and criminal investigation is I think, a pretty damaging thing. So the second area that would be excluded by the proposal I'm making, and incidentally Archie Cox supports this, Jacob Stein, who's been an independent counsel, supports it. Most of them will. It would eliminate investigations or prosecutions for personal misconduct. Now, if for example, there was a lie in a private civil case, the president lied in a private civil case, or he got somebody else to lie in a private civil case, that did not affect his performance of function. It's not pleasant. It's not a good example to be setting the country, and you don't like to think of the person who's responsible for the execution of the law as doing that. But the real question is, does the country want to interrupt his work to make him go through this kind of an investigation now, or is it willing to wait a few years until he's out of office and then go after him then if it's sufficiently serious that somebody wants to do it? So most, as I say, those of us who've been independent counsel thinks that is a good trade-off, that to protect the presidency, not the president, to protect the presidency from interruption. No investigations except for matters relating to the duties of that office. Some person who's been corrupted and done something wrong with the power of his office, okay, he'll have to stand immediate investigation, but not these others. And that comes to the final thing as to which I don't think I don't pretend to be an expert, and that is this sort of almost afterthought that was thrown into the statute, that the independent counsel shall report to the House of Representatives evidence that comes to his attention that may, that's quote, may, close quote, provide a basis for impeachment. Now, we all know the language of the Constitution, that to be impeached it requires proof of a high crime or a misdemeanor of the nature of treason or bribery, which are the other crimes that are specified. But in the last analysis, it's Congress is going to decide that, and Congress is a political institution. I mean, I'm not saying this in any way derogatorily. It's a great political institution. It's the best we've got, but it's a political decision, and a dangerous political decision that's easily rolled over into a development of a quasi-parliamentary system where the majority power in Parliament controls who's going to be Prime Minister. We've fought off that idea here that you can expel a president of a different party just because you don't like the way he's doing his work. But I did hear somebody on the panel argue here a few days ago that impeachment doesn't require a crime, that it can be, if Congress concludes that a president is no longer up to his job, they can just impeach him. I know that in Andrew Johnson's time that it came close to that, but I come back to the independent counsel as the person who started this. I don't care what Congress does as a political unit, a political agency. That's a great responsibility, and as far as I'm concerned, they discharge it well. But the independent counsel is in there as a lawyer, and he's in there as an appointee of the courts, and he's in there looking for crime. And when he starts sending out a whole lot of sexual, explicit descriptions that don't add up to a crime, and send that over to Congress to get them into a state of shock in the hope that perhaps they will extend this ancient and honorable and high and lofty constitutional requirement for impeachment. I don't think that's a good service. I don't see the lawyer doing that, even though he's an excellent appellate lawyer. He may foresee that the law is going to change this way somehow. But it comes back, incidentally, to the lack of prosecutorial experience. You can get the best appellate lawyer in the world. I'm not sure that's an ideal for a prosecutor. A person who's out there working on the edges of the law, where the law is going to be changed and extended or cut back, whereas the prosecutor should be pretty much of a guy who's going down the middle of the road, prosecuting people for those things that they had reason to expect they were going to be prosecuted for, rather than conceiving some new approach to it. But anyhow, we come down in a long, rambling way to this impeachment provision, and I think that I don't know the strengths and weaknesses of the impeachment. To me, it seems terrible that the president could be impeached for lying about sexual misconduct. It doesn't seem to ring with bribery and treason and high crimes and misdemeanors of the past. But even whether it does or whether it doesn't, the statute ought to be changed so that instead of saying the independent counsel must report anything that may be an impeachable offense, it ought to spell out what he must report, whether it must be a crime, and then define, if necessary, a high crime and misdemeanor, so that the independent counsel can't go running off, flooding the internet with thousands of pages. He didn't do it, Congress did it, but giving it to Congress to flood on something that isn't clearly criminal. Anyhow, I've talked too long, and I appreciate your letting me come here. I had a wonderful time, obviously. I wouldn't have talked this long. I thank you very much for your attention, and if there are any questions, Dean, or anything, I'll be glad to do whatever you say.
Well, thank you.
Okay.
Can I pour you some water or anything?
Oh, no, that's fine.
Thank you very much, Judge Walsh. I'll get close to you so we can share a microphone.
Oh, here, I'll get it.
No. That's, I'm just going to, one of our traditions here at the law school is to see what we can do to weigh down your luggage to an impermissible extent.
Well, I may just stay here. I may just stay. It's such a wonderful
Well, that would be delightful. The weather is like this until February, where we have a couple weeks of snow, and then it's spring again.
Yeah.
This, I don't know if you've had a chance to see the real thing out there in the atrium, but we'll make sure you do. This is the gargoyle, which is the symbol of the University of Wisconsin Law School. Upon the demolition of our original building, this was the one thing that survived, and so we decided to make it a mascot. But we would like to give you this replica of it back for your office in Oklahoma City.
I'd love to have it.
It says University of Wisconsin Law School, Honorable Lawrence Walsh, 1998 Fairchild Lecture. So thank you very much.
Thank you very much, Dean. Thank you.
No, I've got a couple. I've got one other item of official business. Another of the traditions of the Fairchild Lecture is that the text of the speech is developed into an article which will be published in the Wisconsin Law Review. And so let me introduce Irene Catelli, the editor-in-chief of the Law Review, and allow you to give her the manuscript.
Irene, thank you for letting me use your law school. You want an envelope? Okay, I'll give you that. Thanks.
Last night, those of us that had the pleasure to get to talk to Judge Walsh at dinner, I think soon discovered that he had been a participant in so many important events and was so willing to talk freely about them that we basically badgered him with questions, and he wondered when he'd ever get back to the hotel and the chance to sleep. So it was with some trepidation that I asked him if he'd be willing to take questions after his remarks today, and he said he wouldn't have it any other way. So if anybody has questions, and let me just ask you if you would kind of repeat your question. The acoustics in this room are wonderful, but we only have one mic for the benefit of all the people in the breakout room. So if you could ask your question loudly and clearly, and Professor Baldwin will certainly do that, I'm sure.
Would you comment on the unanimity of the Supreme Court of the United States in the decision in Clinton against Jones, which seems to be the foundation of this difficulty?
That shows that 9 people can be as wrong as one. That was an awful decision. I don't understand. You know, they're all sophisticated people, and how they could expose a president to this when the trade-off is, of course, the Jones case is to the advantage of a plaintiff trying to prove a case and get witnesses to remember things, to do it quickly. And it's usually to the advantage of the defendant to have it postponed. But it's not, the country has an interest in the president. He's not just an individual who, and although we have a nice statement of law by the Supreme Court as to how we're all subordinate to the law, the tempering it in the national interest, not the president's interest, it seemed to me would be the way to do it. But I never could understand that decision. Yes, sir.
If one thinks together about Watergate, about Iran-Contra, and about our current activities, each seems to have involved some conduct that high officials did not want to become public, an investigation that led to cover-up, to lying, to withholding of materials, to, I take it, a good deal of frustration by the investigating officers about lack of cooperation, to counter charges that the prosecutor takes too long, spends too much money, get about your job. I wonder, you've been able to reflect on this from several sides in these different cases. How does a prosecutor react in such a circumstance, and what concerns might there be about a pretty expectable frustration and anger about these charges affecting the exercise of judgment and of statecraft where charges against the president are involved?
I think that's a very perceptive question. I think a prosecutor and anyone who takes a job with a thin skin is asking for trouble. He has to know going in it's going to be rough. It's not going to be pleasant. The greatest vulnerability of an independent counsel is time and money, and his opponents know it. The longer they can delay him, the more expense they can put him to, the better they like it. I, for example, may have made a fundamental error in relying on document requests to government agencies, thinking that a government agency is a sufficiently honorable group. They'll respond honestly. Well, you know, you learn. But if I had proceeded by subpoena, as I ultimately did, then I would have been drawn into litigation. Each one of these great agencies has enormous legal staffs. I had 10 lawyers. I had, you know, the happy illusion of being over in 2 years. in deciding that 10 lawyers were enough. You had 2 for the CIA, 2 for the State Department, two young lawyers like you coming out to take on the CIA, who are the most accomplished liars in the country. They're wonderful. They're great at it, but they're just, deceit was their game, and we were the deceived. But it's that sort of thing. Now, Starr had the same problem, obviously, but I really don't think he had it. I don't know. I can't say whether he had it as bad as I did or not. In addition to the just the sheer delay and the stringing things out, you had people like Dole attacking. Once I indicted Weinberger for he saved his notes for the book and didn't produce them when they were called for. Dole began to attack about once a month, and then he moved up to once a week. And this was going right on after the jury was to report to the courthouse for Weinberger's trial, and before Bush at the last minute pardoned him. But it's that thing that goes on. Now, one way in which Starr and I differ, at the beginning, I tried to handle the press myself for about a month. I lived in a hotel, and I'd have dinner every night in my room, watch the news, and then work. And I never had a warm dinner because the deadlines for the newspapers would come at dinner time. And so I'd always be up there answering questions. Can I speculate this? Can I speculate that? It goes on and on. They keep shaving it finer and finer, but it takes 45 minutes to get them off the wire. So I finally got a press officer. And then finally we had 2. I think Starr was slow to do that. For the first few years, quite uprightly, he refused to talk at all, to give guidance as to, not against an individual or what your evidence is or exposing a witness, but at least in giving letting a reporter know enough so that he can generally tell his editors they're probably going to go this way or they're going to go that way in general terms. And Starr ultimately did get somebody, but by then I think he'd lost an opportunity to build a relationship that he could have used instead of getting caught all the time outside of his house as he's trying to get into his car, which is what the press can do if they feel you're being non-cooperative, that you could do more properly without harming justice. I know it's just a long way around, but it goes with the game, and it's there. And I think the only thing worse than the public give and take is the sense of the massiveness of the agencies that you're trying to push a little bit. The ability of the National Security Agency just to stare you down and to make false claims that something isn't known anywhere, that you're going to expose people to being killed by terrorists if you force this out. And then you hear, a month later, you hear on PBS a description of the very device that they said we couldn't expose in the North trial. So all those frustrations go into it, but it makes it perhaps more interesting in a lot of ways than another case. Yes?
You were there, Judge Walsh. Do you have any reason to believe that someday in the future we will discover memoirs, unwritten books, tape recordings, anything that would definitively announce whether President Reagan ruled about Iran-Contra in his own
Everything I have is in the archives. I didn't keep any. I kept some copies of original documents, but none of the originals. I don't know what is in the Reagan library beyond those things that I have used myself. I don't know what is there. I just would assume that there would be a fair amount. But first place, President Reagan wasn't the least bit ashamed of what he did. In this meeting I told you about, where they're all saying the president didn't do it if he did his. The president was pounding the table, red in the face, saying, "We didn't trade arms for hostages. We haven't done anything wrong. Well, why don't you just go tell them what we did?" And so that there was a sort of innocence about it in an odd sort of way. A very sophisticated, very powerful, very, 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 very moving person in many ways. But I once talked with Judge Fairchild. His mind reminded me of an American Law Institute restatement. You have the solid black letter. This is what the law is. Then you have several pages of discussion. Why? And then you have a lot of illustrations. Now, the president, as I could understood it, I'm not trying to demean him in any way. I admire him, but as I understood it from his friends and people who work for him, he would absorb all of that detail and get the black letter. But after he did that, he washed it all away, and what he remembered was the black letter, which was his policy, his decision. And if you start asking him questions about how he got there, you'll get very confused answers, as he did with the Tower Commission. You may remember at the same time I was appointed, the president appointed a presidential commission to look into the misuse of the National Security Council staff. And Senator Tower was the chairman. The first time the president was testified before them, he said he authorized the sale of arms through Israel to Iran. Then his staff talked with him and convinced him he hadn't. So he goes back and tells them he hadn't done it. And then the third thing he does is send a letter through his counsel saying the truth is I just don't remember. Now I think he was probably honest in that. His counsel tells of going in there one evening and finding the president trying to puzzle through his diaries and some memoranda and things trying to figure out. And then unfortunately he got Norse chronology, which was deliberately misleading. I don't know, but it was sort of certainly a sympathetic picture of a man, a great man making great decisions, trying to deal with what to him was a detail 3 or 4 years after it happened. Yeah. Yes, sir. I forgot this. Yes.
And if there is to be a re-examination of the whole statute and the way it's constructed, is there a weakness to be addressed which involves the presence of the Senate Judiciary Committee and its conceivable influence on the judicial group that makes the appointment? I'm thinking of the presence of Senator Helms at the head of the senatorial judicial committee that is involved in this process.
I have a suggestion that comes close to that. Lloyd Cutler, and I meant to mention it, it's a very good one. It has certain problems without. Lloyd Cutler, who was counsel to President Carter and then I think briefly to President Clinton, suggested that at the beginning of each presidential administration, the president appoint 25 prospective independent counsel who would be qualified for the work, and then they were to be confirmed by the Senate, and then you would have this pool of available to the judicial division to select from among those 25 pre-approved people. One of the problems there is that the person who would be investigating the president, perhaps, was one who's already been appointed and selected by him, but it would depend, he would have to be confirmed by the Senate, and I would assume that the 25 would be people of sufficient stature that they would be trusted. But I don't know whether that meets your thought at all. Another thing that I've thought of was that the president, certainly during the Eisenhower period and most of the presidents thereafter, I don't know what the present situation is, but there used to be a standing committee of the American Bar Association of lawyers, one from each circuit throughout the country, who would report for the lawyers in their community as to a particular individual under consideration. Now, you might not want to take their advice, but at least you had it, so that it would be better than a committee just going off by itself, depending on its own knowledge of the people who are under consideration. but at least it could get reports from the bar associations that way. Oh, yes.
It seemed to me that the special prosecutor law worked in order, or the way we had it set up before the independent counsel worked. President constitutional problems were addressed. We didn't need an independent, separate institution of independent counsel. And the problem that it seems to me that's created when you have an independent counsel is that you have someone divorced from the normal Washington institutions. That independent counsel doesn't carry with him or her the statute of the Department of Justice when the IC is battling with NSA or Department of Defense, you're trying to get compliance with your document requests. So my question is, did you perceive that you might have been able to roll these agencies or work more effectively with them to get information if your opposing agencies or the other executive agencies identified you more closely with the U.S. Department of Justice as opposed to being the sort of outlier, this thing that no one can really peg into any particular box?
I think the answer would depend upon who was being investigated. If I'm investigating the president, it wouldn't make any difference who appointed me. If I'm investigating a more remote agency or a more subordinate person, then the cooperation might be slightly improved by the judicial support for it, but I think it's pretty subtle. The feeling is perhaps exaggerated that if you attack a key member of the administration, you're indirectly attacking the president, and the tendency is for the administration to pull together against you, I think.
Well, thank you, Judge.
Okay. Well, I enjoyed it very much. Great.
Thank you all for attending. For those